Welcome to the U.S. Customs and Border Protection's Office of Trade Learning Series. The purpose of today's video is to discuss what the Enforce and Protect Act (EAPA) investigations entail. The CBP Office of Trade leads America's trade-related security, enforcement, and facilitation activities to protect U.S. lives, businesses, and jobs. The Office of Trade has several offices and programs that provide uniformity and clarity in implementation of CBP's national strategy. One of these offices is the Enforcement Operations Division, EOD. The EOD facilitates the EAPA allegations process to protect the U.S. economy from the effects of unfair trade practices and guard against the entry of products that could pose a threat to health and safety. The Trade Facilitation and Trade Enforcement Act authorized the EAPA program, and CBP implemented EAPA through regulation in August 2016. EAPA allows U.S. Customs and Border Protection to investigate whether a company or other entity has evaded anti-dumping and countervailing (ADCD) duties in an on-the-record investigation. After officially receiving a properly filed allegation from an interested party, which reasonably suggests that merchandise covered by an ADCVD order has entered the U.S. through evasion, CBP has 15 business days to initiate an investigation. Decisions regarding whether to initiate an investigation under the EAPA will be determined by CBP's Trade Remedy Law Enforcement Directorate, and they will form a team of specialists from different CBP offices, such as the Office of Field Operations Centers of Excellence and Expertise, Trade Regulatory Audit, the Office of International Affairs, as well as other divisions within TFTEA, such as National Threat Analysis Divisions. Within the first 90 days of investigation, CBP will examine if there is enough information to determine reasonable suspicion of evasion and issue interim measures. CBP will then notify all known parties to the investigation about the investigation no later than 5 business days after day 90. After the interim measures notification, EAPA investigations continue and include actively gathering information and coordinating efforts. This may include, but is not limited to, counseling importers or manufacturers on the EAPA process, managing communication with alloters, managing timeline milestones for documentation submission, obtaining relevant documents related to the sales and manufacturing processes of the importers/manufacturers, obtaining samples of merchandise as needed, preparing for verification visits. During this time, CBP has the authority to conduct verifications of information collected in the United States or in foreign countries, as is necessary to make its determination. Verifications in foreign countries will be conducted in agreement with the companies being verified and with the permission of the foreign government where the verification is scheduled to occur. Rejecting documents that do not meet filing requirements, analyzing and synthesizing information, for example, checking for discrepancies across submitted documentation, and finally, developing the findings and concurring with leadership for enforcement actions. At the conclusion of the investigation, CBP will determine whether there is substantial evidence based upon the record that evasion of an ADCVD order has occurred. At this time, CBP will issue a notice of determination to the interested party or parties who made the allegation and to the importer alleged to have evaded an ADCVD order. It is important to note that EAPA requires CBP to take actions within specified timeframes, so understanding the timelines for investigations is also critical. For more information on best practices for filing an EAPA allegation, the investigative timeline, and use of the EAPA Allegations Trade Violation Reporting portal, please visit the EAPA website or contact us through the EAPA inbox.